Hello everybody, welcome to iExamB. Embrace the iExamB learning experience. In this video series, we have been discussing previous year questions, and in this video, we are going to discuss questions from Arbitration Act and Transfer of Property Act, which have come over the past 3 years. Together, Transfer of Property Act, Arbitration, CPC and Limitation holds a 25% weightage. In our last video, we have discussed questions from CPC and Limitation. In this video, we'll be covering up Transfer of Property Act and Arbitration. Starting with the first question, where the ownership of the property has passed to the buyer before payment of the whole of purchase money, the seller is entitled to a charge upon the property in the hands of buyer for the amount of unpaid purchase money. The seller is entitled to rents and profits of property, a charge upon the property in the hands of buyer for the amount of unpaid purchase money and interest, to bear any loss arising from the destruction, injury or decrease in the value of property, to pay all public charges and rent which may become payable in respect of the property. The correct answer here is C. The seller is entitled to a charge upon the property in the hands of the buyer for the amount of unpaid purchase money and interest. This is section 55 of the Transfer of Property Act. Entitlement of seller. The seller is entitled to rents and profits till the ownership passes to the buyer, where the ownership has passed to the buyer before payment of the whole of purchase money to a charge upon the property in the hands of buyer. Question number 2. Which type of mortgage is it, where the mortgagor delivers the possession and right to enjoy an income of and from the property to the mortgagee? Is a simple mortgage, usufructuary, English, equitable mortgage by deposition of title deeds? The correct answer here is usufructuary mortgage. Section 58 of Transfer of Property Act defines usufructuary mortgage. Question number 3. Where the mortgagor ostensibly sells the mortgage property on condition that on default of the payment of mortgage money on a certain date, the sale shall become absolute. This is called usufructuary mortgage, simple mortgage by conditional sale, anomalous mortgage, absolute sale. The correct answer is C, mortgage by conditional sale. Section 58 of Transfer of Property Act defines different types of mortgage. Mortgage by conditional sale have the condition that on default of payment of mortgage money on a certain date, the sale shall become absolute. Question number 4. Where the mortgage property is a lease and the mortgagee obtains a renewal of the lease, the mortgagor upon redemption shall not have the benefits of new lease, have the option to terminate, have the benefit of new lease in the absence of contract to the contrary, have the benefit of new lease despite presence of contract to the contrary. The correct answer is D. The mortgagor shall have the benefit of the new lease in the absence of contract to the contrary. This is section number 64 of Transfer of Property Act, renewal of mortgaged lease. Question number 5. A suit for foreclosure is a suit to obtain a decree that a mortgagor shall be absolutely debarred of his right to redeem the mortgaged property. A suit to obtain a decree that a mortgagor shall be absolutely debarred of his right to redeem the sold property. A suit to obtain a decree that a mortgagee shall be absolutely debarred of his right to redeem the mortgage property. Suit to obtain a decree that a mortgagor shall be allowed to redeem. None of the above. Correct answer here is A. A suit for foreclosure is a suit to obtain a decree that a mortgagor shall be absolutely debarred of his right to redeem the mortgage property. This is as per section 67 of Transfer of Property Act. Here it is clearly said a suit to obtain a decree that mortgagor shall be absolutely debarred of his right to redeem the mortgage property is called a suit for foreclosure. Question number 6. A suit to obtain a decree that a mortgagor shall be absolutely debarred of his right to redeem the mortgage property is called ill. So earlier a suit of foreclosure, definition of foreclosure was asked, and here the definition is given and you have to identify what this definition is related to. Suit for foreclosure, suit for redemption, suit for sale, suit for possession, suit for mortgage. The correct answer is A, suit for foreclosure as per section 67 of Transfer of Property Act. Question number 7. Which of the following is not a duty of mortgagee? Managing of the property, must commit and act injuries to property, keep clear accounts of sum received and spent, both A and B, A, B, C. This is very clear right on the face of it. The correct answer is B. This is not a duty of the mortgagee. This is as per section 76 of Transfer of Property Act, liabilities of mortgagee in possession. He must manage the property. He must use his best endeavors to collect the rents and properties thereof. Question number 8. A lessor is bound to disclose to the lessee any material defect in the property with reference to its intended use, of which the latter is and the former is not aware, and which the latter could not with ordinary care discover. Option B, with reference to its unintended use, of which the former is and the latter is not aware, and which the latter could not with ordinary care discover. Option C, D, and E. You can pause the screen and you can read all the options, compare them. They are very closely related with minor variations in the options. The correct answer here is D. As per section 108, rights and liabilities of lessor and lessee. Rights and liabilities of lessor. A. The lessor is bound to disclose to the lessee any material defect in the property with reference to its intended use, of which the former is and the latter is not aware, and which the latter could not with ordinary care discover. Question number 9. A lessee may remove his property attached to the earth at any time after determination of lease, at any time when he is in possession of property, at any time before he leaves possession of property, at any time after he leaves possession of property. A and B or C. The correct answer is E, A and B or C. As per section 108H of Transfer of Property Act, the lessee may, even after the determination of lease, remove at any time whilst he is in possession of the property leased, but not afterwards, all things which he has attached to the earth, provided he leaves the property in the state in which he received it. Question number 10. When can a lease be terminated? By 6 months notice if agricultural lease, by a flex of time limited thereby, by forfeiture. B and C, all of the above. Correct answer here is all of the above. Option E. This is as per section number 111 A to H of the Transfer of Property Act, which talks about modes of determination of a lease. So these were all the questions from Transfer of Property Act. Now we will be moving to Arbitration and Conciliation Act. Question number 1. Is international commercial arbitration covered under Arbitration and Conciliation Act 1996? No, India does not support international commercial arbitration. International commercial arbitration is carried out in India under separate legislation. Part 2 of Arbitration and Conciliation Act deals with it. Both C and D are correct on this point. The correct answer is option D. Part 2 of the Arbitration and Conciliation Act deals with it as per section 2(1)(f) of Arbitration Act, which defines international commercial arbitration as a legal and commercial relationship, and either of the parties is a foreign national resident or a foreign body, corporate, company, association, or body of individuals whose central management is in foreign hands. Part 2 of the Arbitration Act deals with enforcement of foreign awards. Question number 2. An application for arbitration shall be filed by defendant before submission of written statement at any time when suit on same subject matter is already filed, at any time provided suit on the same subject matter is not filed, cannot be filed, court shall refer matter for arbitration, none of the above. The correct answer is A, by defendant before submission of written statement. As per section 8 of the Arbitration and Conciliation Act, Part 2 refer parties to arbitration where there is an arbitration agreement, a judicial authority before which an action is brought in a matter which is subject of an arbitration agreement, shall, if a party so applies, not later than when submitting his first statement on the substance of the dispute, refer the parties to arbitration. Question number 3. If the parties fail to determine the number of arbitrators, arbitration tribunal shall consist of a sole arbitrator. Arbitration tribunal shall consist of 3 arbitrators. Arbitration tribunal shall consist of 2 arbitrators. Number of arbitrators shall be determined by the court. Court will order the parties to decide on the number of arbitrators. The correct answer is A. Arbitration tribunal shall consist of a sole arbitrator. This is as per section 10 of the Arbitration Conciliation Act. The parties are free to determine the number of arbitrators, provided that such number shall not be an even number. Failing the determination, the arbitral tribunal shall consist of a sole arbitrator. Question number 4. How is the place of arbitration determined? As per the choice of parties, it keeps changing. The arbitration tribunal shall determine cumulative decision of parties as well as arbitrator at the time of hearing, as per the decision of parties determined by arbitration agreement, B or D. Correct answer here is 5, B or D. The arbitral tribunal shall determine, or as per the decision of parties determined by the arbitration agreement. This is as per section 20 of the Arbitration and Conciliation Act. This provides that parties are free to determine place of arbitration. If not, an arbitral tribunal shall determine. Question number 5. If the parties fail to agree on the place of arbitration, the place of arbitration shall be determined by court, determined by arbitral tribunal, having regards to circumstances of case, place of sitting of high court determined by parties as directed by arbitral tribunal. Correct answer is C, determined by arbitral tribunal having regard to circumstances of the case. This is section 20 of Arbitration Conciliation Act. Question number 6. When does an arbitration proceeding actually commence? Request for dispute to be referred to arbitration is received by respondent. Request for dispute to be referred to arbitration is made. Dispute is referred to arbitration when parties appear before arbitral tribunal when first hearing takes place. Correct answer here is A. Request for dispute to be referred to arbitration is received by respondent. This is as per section number 21 of Arbitration Conciliation Act. Unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Question number 7. What is the language used by arbitral tribunal? Parties are free to determine among themselves. Arbitrators shall determine only English or Hindi, English only, Hindi only. The correct answer here is 1. Parties are free to determine among themselves. Parties are free to determine by an agreement about the language to be used. If at all not decided, then arbitral tribunal shall determine the language. Section 22 of the Arbitration and Conciliation Act deals with the language to be used by arbitral tribunal. Question number 8. Which of the following is part of fast-track arbitration? Parties may omit oral hearing. Parties only conduct oral hearing. There are only 2 arbitrators appointed. Procedure is completed in 15 days. Procedure is completed in 3 months. The correct answer here is A. Parties may commit oral hearing. This is given under section number 29B of Arbitration and Conciliation Act, fast track procedure. Question number 9. The arbitral tribunal shall issue an order for the termination of arbitral proceedings where the arbitral tribunal finds that the continuation of the proceedings has for any reason become unnecessary, the arbitral award has been passed, the arbitral proceedings have prolonged, the award cannot be passed, the dispute has been rejected. Correct answer here is E. Arbitral tribunal finds that the continuation of proceedings has for any reason become unnecessary. This is section number 32 of the Arbitration Conciliation Act, termination of proceedings. Question number 10. In which of the following cases can courts intervene in an arbitral proceeding? When arbitration is completed, when arbitration fails, when it is proved that one of the party was under some incapacity, when arbitral order is signed. In no case courts shall intervene in an arbitral proceeding. Correct answer is C. When it is proved that one of the party was under some incapacity. This is section number 34 of the Arbitration and Conciliation Act, application for setting aside arbitral award. You can pause the screen and read this entire section, or you can just go and read from the bare act. Question number 11. On death of party, arbitration agreement shall be discharged by the death of any party thereto, either as respects the deceased or as respects any other party. Shall not be discharged by death of any party thereto, either as respects. Shall be discharged by the death of any party, shall not be. So very closely options are placed over here, just as the way you see in the exam. You can pause the screen here, you can read all the options and try to understand, try to recognize the difference between the options. The correct answer here is C. Shall not be discharged by the death of any party thereto, either as respects the deceased or as respect any other party. This is given under section number 40 of Arbitration and Conciliation Act, arbitration agreement not to be discharged by death of party thereto. Question number 12. An arbitration shall be deemed to have commenced on the date on which a request for that dispute is made, on the date on which a request for that dispute is referred to arbitration, on the date on which a request for that dispute to be referred to arbitration is received by respondent, on the date on which a request for that dispute to be referred to arbitration is received by plaintiff, on the date of occurrence of dispute. Correct answer is C. When the date on which a request for that dispute to be referred to arbitration is received by respondent. This is given under section number 43 of Arbitration and Conciliation Act. For the purposes of this section and Limitation Act, an arbitration shall be deemed to have commenced on the date referred to in section 21. And then section 21 says, unless otherwise agreed by the parties, the arbitration proceeding in respect of a particular dispute commence on the date on which a request for that dispute is to be referred to arbitration is received by the respondent. Question number 13. The conciliator may at any stage of the conciliation proceedings make proposals for a settlement of dispute. Such proposals need to be in writing but need not be accompanied by a statement of the reasons, need not be in writing and no need of stating reasons, need not be in writing but reasons need to be stated, need to be in writing and need to be accompanied by statement of reasons, need not be in writing and need not be accompanied. The correct answer here is E. As per section number 67 of Arbitration and Conciliation Act, role of conciliator is given over there. So these are all the questions from Arbitration and Conciliation Act which have come over the past 3 years. From our SEBI legal course, 12 of our students have got selected and you can be next. We have been helping and guiding students over the past 3 years in their dream of SEBI legal officer. If you need any form of guidance, preparation material, study notes, mock tests, you can check out our courses. We at iExamB help you prepare 50% faster with a crisp and concise content. Subscribe to our channel. Stay tuned. Thank you.